I was convicted of criminal harassment for sending messages I had never written from an account I had not logged into in 11 days. The detective assigned to the case had my phone in his possession for 6 hours. He checked the outbox. He saw the messages. He did not check the login history, the device access records, or the IP address from which the account had been accessed on the night in question. These are three separate things that take approximately 4 minutes to look up. He did not look them up. He filed his report. The district attorney reviewed it, and I was charged. I want to be fair to the detective for exactly one sentence. He had a confession from my ex-partner that I had threatened him, a series of messages that appeared to come from my account, and a prior domestic disturbance call that had been filed 6 months earlier. On the surface, the case looked straightforward. The surface was the problem. My phone was a piece of evidence in a case against me, and it sat in a plastic bag in a police property room for 4 months. Every time I thought about that, my phone, in a bag, being used to convict me of something I had not done, I had to actively choose not to find it funny, because the alternative was sitting on the floor of my apartment and not getting up. I chose funny. It was the only option that kept me functional. The retention anchor, my ex-partner, a man I will call Tyler, had known my account password for 2 years. I had changed it after we separated. He had been present when I changed it. He had watched me type the new one, and I had not realized at the time that this was a thing I needed to think about carefully because I had not yet understood the full scope of what Tyler was capable of when he felt he had something to lose. The former complainant was a woman named Alicia. Same detective, different case, 3 years earlier. Quiet and precise in the way of someone who has been disbelieved before and has adjusted accordingly. Alicia's case had been dropped without explanation 18 months after she filed. She contacted my attorney through a legal advocacy organization after reading a brief mention of my case in a local news item. She had her own documentation. She had been waiting for someone to ask for it. My attorney was a woman named Sandra, criminal defense, with the darkly amused quality of someone who has seen this particular flavor of incompetence before and has stopped being surprised by it. Sandra said, on our second meeting, "The good news is that whoever did this left a trail. The bad news is that the detective who investigated did not follow it, and now we have to do his job for him in front of a judge. And judges do not love being shown that." Sandra filed a motion for post-conviction relief based on newly discovered evidence, the category of legal relief available when evidence surfaces after conviction that could have affected the verdict. She requested the server logs from the messaging platform directly, through a subpoena to the company, rather than through the original investigation. The logs arrived on a Thursday. Sandra called me on Friday morning. She said, the account was accessed from Tyler's home IP address at 11:47 p.m. on the night the messages were sent. His address, his IP, his home network, his device fingerprint in the server log, accessing my account 11 minutes before the messages appeared in my outbox. The midpoint is what Sandra said next, which was, "This is enough to vacate the conviction." Then she paused. Then she said, "But I want you to think about what else you want to do with this." What she meant was the civil lawsuit. What she meant was that a server log proving Tyler had accessed my account without authorization, sent messages designed to look like mine, and presented them to police as evidence of my harassment of him was not just a defense, it was a case: unauthorized computer access, identity fraud, filing a false police report, potentially obstruction. Sandra said she could name 4 causes of action without trying hard. I said, file everything. She filed the motion to vacate and the civil complaint on the same day. Tyler's attorney responded to the civil complaint by arguing that shared passwords in a prior relationship constitute implied access permission. Sandra's response to this argument was 6 pages long, and I will summarize it as, "No, they do not," and here is why in considerable detail. The hearing on the motion to vacate is scheduled for next month. The civil suit is active. Alicia's documentation is part of our record now, a pattern of cases involving the same detective, the same failure to check login records, all involving complaints by men against female ex-partners. Not a coincidence. A pattern. I have my phone back. It is no longer in a plastic bag. I charged it when I got it home and it powered on immediately, which felt like a small defiance against everything that had happened. This object just quietly continuing to work while the legal system tried to use it against me. The conviction is still on my record until the hearing. That is the part I cannot make funny yet. It is there right now, in a database somewhere, describing me as a person who did something I did not do. Every background check, every job application, every form with a box that asks about criminal history. One more month, then part two. And Tyler still has not been charged with anything. That is the part I am waiting to tell you about.